The K-1 visa is a special visa designed for fiancés of U.S. citizens. It allows the foreign national fiancé to enter the United States for the purpose of marriage. Upon entering the U.S., the couple must marry within 90 days. After the marriage, the foreign national spouse can then apply for a green card to stay in the U.S. permanently. The K-1 visa process can be complex and time-consuming. Seeking guidance from an experienced immigration attorney can be beneficial. If you are a U.S. citizen engaged to a foreign national, the K-1 visa is the appropriate visa category to pursue. Understanding the requirements and process will help ensure a successful outcome. Start your lives together in the U.S. with the K-1 visa. Before a U.S. citizen can bring their fiancé to the U.S. on a K-1 visa, certain requirements must be met. The couple must have met in person within the 2 years before filing the petition. Both the U.S. citizen and their fiancé must be legally free to marry. Documentation proving the termination of any prior marriages must be provided. The couple must demonstrate their intention to marry within 90 days of the foreign national fiancé's arrival. The U.S. citizen petitioner must meet certain financial requirements to sponsor their fiancé. This can be proven by providing proof of income, assets, or an affidavit of support from a joint sponsor. Both the U.S. citizen petitioner and the foreign national fiancé will undergo thorough background and security checks. These checks ensure national security and public safety. The K-1 fiancé visa process involves multiple steps. The first step is for the U.S. citizen petitioner to file Form I-129F, Petition for Alien Fiancé, with USCIS. Once USCIS approves the I-129F petition, it is sent to the U.S. Department of State for further processing. The DOS will forward the approved petition to the U.S. Embassy or consulate in the foreign national fiancé's home country. The fiancé will then need to apply for the K-1 visa at the U.S. Embassy or consulate. The foreign national fiancé will be required to attend an interview at the U.S. Embassy or consulate. During the interview, a consular officer will assess the legitimacy of the relationship. If approved, the foreign national fiancé will be issued a K-1 visa allowing them to travel to the United States. Upon arrival, they will undergo inspection by U.S. Customs and Border Protection at a port of entry. If the foreign national fiancé has unmarried children under the age of 21, they may be eligible to apply for K-2 visas. The K-2 visa allows the children to accompany or follow their parent who is entering the U.S. on a K-1 visa. To include children in the process, their names and information must be included on the initial Form I-129F filed by the U.S. citizen petitioner. The children can travel to the U.S. with their parent or join them later. However, they must travel to the U.S. before their parent marries the U.S. citizen petitioner and before their K-2 visas expire. Once in the U.S., the children are subject to the same 90-day time frame as their parent to have their status adjusted to lawful permanent residency based on the marriage. It's important to note that K-2 visas are dependent on the K-1 visa of the parent. If the K-1 visa is denied or revoked, the K-2 visas for the children will also be invalidated. The children must remain unmarried and under the age of 21 to maintain their K-2 status. If they marry or turn 21 before adjusting their status, they will no longer be eligible for a green card through their parents' marriage. The process for obtaining K-2 visas for children is relatively straightforward. The U.S. citizen petitioner should include the children's information on the Form I-129F. Once the petition is approved, the children will need to complete their visa applications and attend an interview at the U.S. Embassy or consulate in their home country. The K-1 visa is only valid for 90 days from the date of entry into the United States. Within this 90-day period, the foreign national fiancé must marry the U.S. citizen petitioner who sponsored their visa. If the couple fails to marry within the allotted time frame, the foreign national fiancé will be considered out of status and subject to removal proceedings. After the marriage, the foreign national spouse can apply for a green card, also known as lawful permanent residency, based on their marriage to a U.S. citizen. This process involves filing Form I-485, Application to Register Permanent Residence or Adjust Status, with USCIS. The green card application process typically involves providing extensive documentation to prove the bona fide nature of the marriage. This documentation may include joint financial records, proof of cohabitation, and affidavits from friends and family members attesting to the legitimacy of the relationship. The foreign national spouse may also be required to attend an interview with USCIS to discuss their marriage and relationship history. Navigating the K-1 visa process and subsequent green card application can be complex. Consulting with an experienced immigration attorney is highly recommended for personalized guidance and support.